Hello everyone. Today we are going to see about the important judgments of August 2023. Case 1, Ramesh Chand vs. Management of Delhi Transportation Corporation 2023 LLR 827. The following significant observation and findings were expressed in this judgment. 1. On order of removal from service of a worker may be annulled if management fails to prove the allegations against the worker with compelling evidence before the adjudicator. 2. If an investigation is proven to be tainted, the employee is entitled to reinstatement with back pay. 3. In order to be entitled for back pay, the employee must first plead and establish that they were not gainfully employed following their discharge. 4. If the workers declares in their affidavit in evidence that they have been jobless from the date of termination, it will be assumed that they have been unemployed since the date of termination. 5. When the worker during cross-examination denies that they were gainfully employed, the duty shifts on the management to establish otherwise with the compelling proof. 6. The worker will not be entitled to back pay for any delay in filing a labor dispute. 7. If management fails to offer evidence that the worker had alternative source of income, they will be required to pay back wages if the termination decision is overturned. Ramesh Chand vs. Management of Delhi Transportation Corporation 2023 LLR 827. 8. Back pay is not automatically awarded upon reinstatement. It is determined by the facts and the circumstances of each case. 9. If the worker withdraw on earlier affidavit including information about their unemployment and files a new affidavit that doesn't include their unemployed, they cannot be paid back earnings for the full period. 10. It is unacceptable that the worker has no source of income for the whole 13-year period. 11. If management fails to pay the granted sum to the worker within the time restriction, they must pay simple interest at a rate of 9% per annum. In the specific instance detailed in the opinion, in the appellate was a Delhi Transport Corporation conductor who was fired for a variety of reasons. The Labour Court ruled that the investigation was untrue and ordered the appellate reinstatement but refused back pay. The appellant claim for full back wages was partially upheld with the respondent ordered to pay rupees 3 lakhs in back wages. Shashi Bala Meena vs. Punjab National Bank and others 2023 LLR 863 Rajasthan High Court. The ruling concerns a writ case brought by the petitioner who worked for the United Bank of India. The petitioner requested the revocation of several directives including her forced retirement as well as reinstatement with benefits. The petitioner's attorney contended that the petitioner had been transferred numerous times, received promotion and had kept a clean service record with no fines issued during her tenure. Due to financial circumstances, the petitioner was shifted to the Alwar branch but asked to be maintained at the Jaipur branch. She requested for medical leave when her request was refused, but her relieving order was issued without providing leave. As a result, she was subjected to disciplinary investigation which she felt was unjust and hasty. The petitioner also claimed that she had genuine medical grounds for her absence which were not taken into account during the investigation. Respondent counsel argued that the petitioner had other options such as review under the United Bank of India Officers Employees Discipline and Appeal Regulation 1976. They claimed that the petitioner's move was in compliance with the order, but she had purposely remained gone for 6 months without leave. They further stated that The petitioner had filed a bogus FIR against the bank employees. They maintained that because the medical certification were obtained by private practitioner, they were invalid and therefore privileged leave could not be sought as a matter of right. In a response, the petitioner attorney contended that review procedure had already been exhausted, that the medical certification were issued by government medical authority, that the petitioner's 6-month absence did not require compulsory retirement. The petitioner's service record was mostly immaculate and her absence was due to personal circumstance. According to the court, it acknowledged the principle of proportionality in considering the propriety of the sentence and determined that mandatory retirement was disproportionate to the offence. The court also stressed the significance of fairness in administrative decision that influence on employees' livelihood. As a result, the court overturned the challenged order and remanded the case to the relevant authorities for reconsideration of the sentence. The petitioner was ordered restored but not paid back wages. In summary, the court overturned the petitioner compulsory retirement order, noting disproportionately, and ordered her reinstatement without back pay, highlighting the need of justice in administrative judgments. Wonderla Karmika Sangha versus the Management, Mr. Wonderla Holidays Limited and another, 2023 LLR 886, Karnataka High Court. This case is an industrial dispute involving the transfer, sacking and suspension of over 100 workers by a Bangalore-based contractor. The workers, who were represented by a union, brought this matter to an industrial tribunal for resolution. The tribunal decision upheld the contractor activities, but the major employer, the company that contracted for the job, was not named a party to a dispute. Following that, union filed a writ petition to overturn the tribunal judgment. The High Court maintained the tribunal ruling, holding that the major employer was not an essential party to the case, despite an earlier decision by a district and session judge. The following are the important points and decisions in this judgment. 1. Because there was no direct employment link between the primary employer and the contract workers, the industrial tribunal and the High Court agreed with the principal employer that it was not required to be party to the dispute. 2. The fact that the primary employer did not object to non-involvement before the conciliation officer did not imply that it should be named a party in the writ petition before the industrial tribunal and the High Court. 3. The ruling cites various legal precedents in support of the position that the major employer may only be impleaded as a party if the industrial tribunal determined that there is adequate grounds for such impediment throughout the course of the dispute. In essence, this decision confirmed that the lack of a direct employer-employee connection between the primary employer and the contractor employee might be a valid grounds for not involving the principal employer in an industrial dispute. It does, however, leave open the potential of charging the main employer if sufficient reason is established throughout the procedure. In one example, the writ petition contesting the tribunal ruling was denied. In another, it was granted.